All right, we covered this a little bit, but can I or can I not choose my physician?
You can choose your physician to a certain extent. Now, initially, when you report your claim to your employer, 9 times out of 10, your employer is going to direct you to a particular healthcare provider. Then, if you're not satisfied with that healthcare provider, you can request for a change of physician, and this is a new law in 2008, and then at which point in time your employer will give you a list that you can choose from of healthcare providers from a different facility, or in the alternative, you can just request the insurance company to give you a name of a different physician, or you can request the name of a different physician to begin treating, and if they don't respond within 20 days, then it's automatically authorized, or you can petition the court.
All right. In addition to my medical benefits, what other type of benefits am I entitled to receive under workers' compensation?
Now, if your employer admits for the claim or you win at hearing, you're entitled to all medical benefits. You're entitled to mileage reimbursement. You're entitled to wage loss benefits. And in the work comp system, these are called temporary total disability benefits. And they figure those out based upon your average weekly wage. And it's 2/3, which is about 66% of your average weekly wage. That's what you're entitled to receive once a workers' compensation doctor states that you're unable to work for a period of time. Then you continue to treat until you reach a point called maximum medical improvement. And then after that point, you get a permanent impairment rating, and then you be entitled to permanent partial disability benefits.
Do I get these benefits even if I cause the accident?
Yes. It's a no-fault system, so regardless of who caused the accident, if it was a coworker, if it was your employer, if it was due to your own negligence, if you were at fault in causing a car crash, you're automatically entitled to benefits if you can prove you were injured on the job.
Can I get more if I prove that one of my coworkers was negligent or caused the accident, or my boss did?
In most situations, you cannot. Certain exceptions, but in most situations you cannot. Your workers' compensation claim is your sole and exclusive remedy, which means you have no other remedy against your employer for this injury.
What if I'm on the job and somebody who's not working, for instance in a car accident, or somebody who's come into the place of employment is the person who injured me? Do I still get all these benefits?
You do. Not only do you get workers' compensation benefits, but you can also make a claim for third-party benefits. It's called a third-party claim or action. And it's a whole different group of benefits and damages that you can receive for your losses. And you can even choose not to go through the work comp system and simply proceed against the third party that had caused your injuries. For example, if you were on the job and involved in a car crash and the other party was at fault, you can forego the entire work comp system and just go after the at-fault party to recover those damages that you would receive in that particular action.
You know, we hear about this thing called maximum medical improvement in workers' compensation. What is that?
That's a point when the doctors think that you're as good as you're going to get. Not that you're 100%, but that your condition has plateaued and that further medical care and treatment will not improve your condition.
All right. Let's say I reach maximum medical improvement. Can I still get additional medical care, or are they going to cut it off on me?
Yes, that's a good question. Most insurance companies will attempt and will tell unrepresented claimants that you've reached maximum medical improvement, so you're no longer entitled to any benefits whatsoever, when in fact that's not accurate. You're entitled to ongoing medical treatment, medical maintenance, prescription medication, anything it takes to maintain that level of maximum medical improvement. And should your condition get worse, you can always, within a reasonable time, reopen your claim due to a worsening of condition.
Is that all paid for by the employer still?
The employer, it's a self-insured employer or the workers' compensation insurance carrier.
Well, how long can that go on?
It can go on for your entire life if your treating physicians deem it necessary.
All right. I guess my last question in this area would be, if somebody not on the job has hurt me and I'm collecting all this workers' compensation money, can I still go sue them?
Absolutely. Let's use the at-fault party example in the car collision case if you're rear-ended. Now, first of all, you can collect all your workers' compensation benefits. When I say all, I mean medical, wage loss, permanent partial disability, things of that nature.
Well, but let me stop you right there. What am I not getting? that I could usually get in a car accident.
Okay, in a civil claim, a car accident case, you can get damages for such as economic losses, which would be a lot like the medical benefits. However, in a car crash case, you would not be limited to 2/3 of your average weekly wage. You could recover your entire loss of wages regardless of the amount. You wouldn't be subject to any limits or caps. Also, you could recover money for all your harms and losses, including permanent impairment, disfigurement, loss of enjoyment of life, pain and suffering, physical limitations and impairments, and things that aren't offered under the work comp system.
So I don't get those things in work comp.
No, not at all.
But I can still bring my lawsuit to get those things from the other party, from the negligent party.
That's correct. In the work comp system, it's the amount you're entitled to receive is very, very limited to the legislature's creation of what they have deemed as permanent impairment ratings and the amount of money you're entitled to receive based upon those ratings.
All right, if I start that lawsuit, do I have to tell the work comp people that I'm doing it?
Yes, it's a notice of a third-party action, and best case is just to notify them as soon as possible. As soon as you think you might be proceeding against a third party, you should notify them.
Well, what if I don't?
If you don't notify them, you could be subject to certain penalties, and that could be a variety of different penalties. Mostly, if you recover money that the work comp carrier thinks that they're entitled to receive due to a right of subrogation, you could be waiving your entitlement to that.
Sounds like it's a complicated system, but it's not, both sides.
No, I would say it's pretty complicated either way you go. It can be very easy in certain cases, such as an extremity injury where your employer automatically admits for it, and you have no problem with the insurance carrier admitting for benefits, and maybe you just want to consult with an attorney, and then you might be able to handle it on your own. In another situation, if you're involved in a third-party car crash while you're on the job, you can be entitled to work comp benefits, you can be entitled to benefits through a civil lawsuit or a claim you make against the at-fault party. Then it can get very complicated because the work comp carriers can have what's called a right of subrogation, which means they have a right of reimbursement for anything that they pay out to you. They get to get repaid from whatever you collect from the at-fault party.
Sounds like a good idea to at least consult with an attorney.
At the very, very least. It is, you can be subject to penalties. If you make the wrong mistake at the wrong time, the penalties can be very harsh, $500 a day, should you violate any provision of the Workers' Compensation Act.